Sports in Africa is evolving. It has grown from simple recreation into a sophisticated, high-stakes commercial sector.
I feel like sports is no longer just about the competition. It is also a big commercial hub where a lot of commerce and industry can be seen.
I'm a proponent of having disputes resolved at the source, where the disputes are arising. And so having to go to Europe, in my view, is not something that is very ideal.
But with big investments come complex disputes. Join Dr. Murigi, Registrar and CEO of the NCIA, and Mr. Bernard Murunga, Chairperson of the Sports Dispute Tribunal. Discover how they are working together to position Nairobi as the premier hub for sports-related commercial and disciplinary disputes. Are African institutions ready to rise to the occasion?
Good morning, everybody, and welcome to this short introduction. Today we are at NCIA, the Nairobi Center for International Arbitration. We are pleased to be joined by Mr. Bernard Murunga, who is chairperson of the Sports Dispute Tribunal. We want to have a short conversation on the convergence of sport law and international arbitration, and we're trying to see how can we position Nairobi as a premier seat for sports-related commercial and disciplinary disputes in Africa. So we are very glad that you could join us, Mr. Murunga. Thank you so much for offering your time and also putting aside your thoughts to come and share with us some of the things that we believe can help NCIA and Sports Dispute Tribunal enhance our mandate in Africa.
Thank you for having me.
Yeah, karibu sana.
Asante.
Yes. We have seen that there is a growth in sports industry in the country. I think it's a big thing for especially Africa and more particularly Nairobi. And we are beginning to see some sophistication in the way commerce is being done for sports, and we are anticipating that as it continues to evolve, we need to have ourselves prepared for a nearly equivalent sophistication in terms of dispute resolution. And from where you sit as your organization and where we sit as NCIA, where we deal with sports-related disputes from a commercial angle, we'd like to have a short discussion. And I want to begin with you. Can tell us from where you sit in the Sports Dispute Tribunal, what is the current landscape on disputes in Kenya? What does that look like? What kind of matters are coming before the tribunal? And how has that changed in the recent years at the tribunal?
Thank you, Dr. Murigi. So in terms of the sports landscape in respect of dispute resolution, I will go back to 2013 when the Sports Act was enacted, and the Sports Dispute Tribunal was then established under that act and given the mandate to resolve disputes. Just like any other part of the society, the sports world also has its fair share of disputes and also conflicts. In fact, when we speak to our court users sometimes, they are wary of using the word dispute because sometimes it sounds like it is, people are fighting. Sometimes people think it's probably best to just talk about, appeals, so that, but we appreciate that the Sports Tribunal also handles other matters that are not just appeals, because there are also claims that come before it. Now, the matters that come before us, I can classify them as they are the contractual disputes that come before the tribunal, especially endorsement, sponsorship, player contracts. Those are some of the matters that we handle at the tribunal. We also have eligibility and selection disputes, where athletes can come before the tribunal to find out, to just complain about not being selected, especially to the Kenya national teams. We also have disciplinary cases that come before the tribunal. I would go as far as even putting doping matters as a disciplinary issue, because people then get to be suspended from playing. But other than that, there is also on-field and off-field disciplinary matters that are handled by the tribunal. And then there are also governance issues because sports organizations then are also required to be registered under the Sports Act. And what I can tell you is that we seem to be having more of the governance issues than any of the other matters. Out of the 102 matters that were filed in the sports division at the tribunal, so we have the sports division and we have the doping division. So the doping, we had about 62 matters. In sports, we had 102. 53 of those were governance issues. So there seem to be more governance-related matters that are coming in at the tribunal. And so that, I think, is a shift. I actually used to think that we should have fewer governance issues as the Sports Act takes effect. We've now done 13 years of the Sports Act, so you hope that governance issues have settled, but there seem to be still the majority of the matters there. But that doesn't take away from the fact that there are these other matters, the contract disputes, they are also increasing. The fact that people are filing more and more cases at the tribunal then means that there is also confidence that is growing within the tribunal that you can actually have your matters resolved at the tribunal. So that's what I think I will describe as the shift through the years. And then I think maybe when I'm talking about this shift, I think the Nairobi Center for Institute for Arbitration, I think we should be able to have a conversation with the sports tribunal. How then does that dovetail in? Are there matters that, from what I've listed, that NCIA can actually then also be involved at the tribunal?
Oh yeah, thank you for that question. We at NCIA deal with commercial disputes, and most of them touch on contractual arrangements, supply chain, construction, and other international disputes. So we see a clear converging point where when sports players and commercial-related investors in the sports industry are able to consider as a dispute resolution platform the Nairobi Center for International Arbitration. NCIA was inceptualized in 2013 also, and we began operations in 2015. We have continued to see an increase in number of cases that are commercially related, both from private sector and also government-related transactions, and also we are growing into the space of international arbitration. And so we are seeing more and more of cases related to contractual and commercial disputes being referred to the center. So from what you have said, I would see a clear converging point in terms of maybe the governance disputes that are arising, also the commercial related disputes. I think now I feel like sports is no longer just about the competition. It is also a big commercial hub where a lot of commerce and industry can be seen. We are seeing a lot of advertisement, a lot of contract-related, engagements, both domestic and international. We are seeing investors coming to invest in the sporting industry. We are seeing huge constructions being done in the country and in all over the world, actually. So I think for NCIA, we want to have ourselves prepared to be able to offer that assurance to the people who come to invest in Nairobi and in Kenya, that there is a center where dispute resolution can be done in a reliable, credible and efficient manner. One of the assurance that we give to the parties is that when you bring your dispute to NCIA, you will be assured that at the end, and this is arbitration and mediation, you will be assured that first we will make sure the process is transparent. We have contained in our rules every step of the way of what we will do with the dispute. Secondly, we are very clear in terms of managing costs for the parties. And third, we also try and make sure, or rather, we make sure that timelines are clearly observed. If parties agree that they want their disputes resolved as an emergency arbitration and emergency mediation, we have clear timelines in our rules that then provide for that platform. So we have certain areas where we can actually converge. But now coming back to you, the tribunal, I'm hearing as though there are volumes of disputes that are increasing, and they have a commercial underpinning with them. Where do you see the role of the tribunal in encouraging the uptake of alternative dispute resolution mechanisms such as arbitration, mediation, or is there an overlap? Should parties be encouraged when they come before the tribunal to consider other alternative dispute resolution mechanisms?
Thank you. Thank you for that question. Just taking up from what you also mentioned, there is actually mention of the word arbitration in the Sports Act. So, when you see the word arbitration, then I'm also thinking, that is where I think there is that interlinking with the Nairobi Center for International Arbitration. When the Act was conceptualized, they regulated sports. So we actually have a regulator who is a sports registrar. And under the Act, that section 45 2D, they actually give powers to the registrar to even arbitrate on registration disputes. So already there is arbitration being mentioned at the very beginning of, And then when you go now to the establishment of the Sports Dispute Tribunal, which is established under Section 55 of the Sports Act, it then goes ahead. Actually, just before Section 55, you look at Part 7, which sets up the tribunal. It talks about arbitration of sports disputes. So the word used is actually arbitration. So the word arbitration appears there. We have the jurisdiction that is set out under Section 58 of the Act. But even further, now Section 59 goes ahead to say, in resolving those disputes, the Sports Dispute Tribunal can now use arbitration and other mediation, now the alternative dispute resolution mechanism. So there is actually an obligation on the tribunal to then use arbitration as a means of resolving these matters. And I think that's for a good reason, because some of the parties that come before the tribunal, they are having a continuing relationship. You will have, if you talk about, for instance, the governance matters, you have somebody who is governing the federation, and those ones who are governed. The relationship will continue whether or not that dispute goes one way or the other. So it's important that where you have continuing relations, then it's important that certain forms of arbitration that are not very, adversarial are adopted. And I think that is why arbitration is actually a preferred form of dispute resolution. The number of cases is increasing. We I think since inception, the tribunal has handled almost 900 cases. So, and as I mentioned, last year alone, in 2025, we handled 164 cases in total. So that's a good number in terms of what you're mentioning, that there are certain things that then need to be brought out. We look at the law. The law sets out various provisions that organizations should use. If I can give an example, for instance, every sports organization is supposed to have a constitution. The law then goes ahead under Section 46 to say that in those constitutions, there must be certain minimum clauses. And I think for me, one of the clauses that has to be in a constitution is dispute resolution. Right. Then that's where you need to look at how do you resolve the matters. If there is arbitration as a form of dispute resolution, before you escalate it now to the tribunal, that I think is a preferred mode of settlement. And that then would mean that even when people are doing their contract, they are also then looking at arbitration as a form of dispute resolution mechanism. There is what I will call 3 layers of dispute resolution within the Act. You have the internal dispute resolution mechanism, then you escalate to the Sports Dispute Tribunal. Then the third layer is supposed to be now the Court of Arbitration for Sports. Again, the word arbitration is in Court of Arbitration for Sports. So that's why I'm saying that there are a lot of linkages between what the tribunal does and what you are also doing.
Yeah, absolutely.
And I think one of the things that I can also then talk about is, let me just mention Section 58 is very wide, because when it talks about our mandate, it actually talks about resolving sports-related disputes. That's a very wide word, and as you mentioned, even construction of a sports stadium can actually even be sports-related. Right. And a lot of people then say, where do you now put the scope of what is sports? What is other related? But just thinking about it and that nature of sophistication of sports contracts, I don't know what you will be looking at as your advice to those agents who are now drafting contracts, having a look at the, your practice, how do you think the contract should be worded?
Thank you, Bernard. There is a really good point that you've raised there about the 3 layers of dispute resolution that then needs to be thought about before even the dispute arises. And I think at the very inception, when you talked about the Constitution, I really like that, because the Constitution should actually capture what the internal dispute resolution mechanisms would look like. Because for me, what I see there is the need for the drafters of the contracts or the drafters of those constitutions to be aware of what kind of disputes would arise, and also to anticipate the type of resolutions that they would want that are, like you said, amicable, that maintain relationships, that minimize costs, minimize delays, so that then when the Constitution is being drafted, the drafters are very clear. So it's important that is not just done as a last resort. The way people are drafting contracts, they go to the main things and then they remember, or maybe there will be a dispute, and not give clear thought on what then should be the dispute resolution platform. And that is what I see in many other contracts now having a challenge, because the drafters of the contracts need to be aware that dispute resolution is not just a last resort. It is one of the main assurances that you need to have in a good contract. So parties need to be advised to, when drafting contracts, to be clear on the dispute resolution platform. So we have at NCIA a dispute resolution clause that every party can include in their contracts whenever they are drafting a contract, whatever it is, whether it is for athletics, merchandise, whether it's for advertisement, whatever type of contract that parties are entering into, they should look at our clause. If you go to our website, you will see the clause that we have that basically anticipates. Some disputes don't need to go through the traditional arbitration as we know it, where we then appoint an arbitrator, you file pleadings, you file statements of claim, responses, and then an arbitrator makes a decision. Some of them just require mediation. And for you to be able to anticipate that, and for sports, I feel like mediation would actually be much more suitable, because then it maintains what you said earlier. Clear relationship with the parties is maintained. It is amicable, and also parties are encouraged to come up with a solution to their own problem. So the mediator basically just facilitates communication that has been done. So the clauses must be fit for purpose. If it's a commercial related transaction that has significant amounts that are in question in relation to that sports contract, then it is important that the drafters be very careful on what clause to put there. We have seen clauses that are not indicating, 1, what is a dispute resolution platform? 2, what are the rules that are going to be used? 3, what is the applicable law? So those are some of the considerations that drafters of a constitution or contract need to have in mind, and even a constitution need to have in mind as they're thinking about a contract. So it is a specific thing that must be thought through, and not just as a matter of last resort. And maybe coming to your end as a sports dispute tribunal, and of course you interact with these sporting documents and the constituting documents, you talk about governance documents. What are some of the drafting failures that you have seen in terms of how the contracts have been worded or how the arrangements have been made within the sporting industry, and what are some of the things you have observed that can be used to guide and to help the public become aware of how to do it?
Thank you, Dr. Murigi. I still have to remember that we are a court, so I don't want to be trapped in a way that I say, if you do it this way, then you will get your decision, through the tribunal. But what I can say, because the tribunal is actually a court. If you look at the Constitution and Article 169, tribunals are subordinate courts, and as courts, we then look at the evidence that is placed before us and then decide on the cases on a case-to-case basis. But what I could just mention, and also just picking up from what you talked about as the ingredients of the contract, other than just the dispute resolution clauses and the seat of where the dispute should be handled, there are also other matters that those who draft those various contracts need to look out for things like, for instance, the term of the contract. Because, some of the athletes, when they get into this contract, they're getting into those contracts at their prime. And you find there are contracts that are short-term, others that are long-term. I know that, for instance, there was a time Kenyan football teams were saying that they would want to have short-term contracts so that they can easily, if you want to have a termination, then you would. It will be easier. But then that also led to greater costs, because then it meant you are doing a lot of renegotiation after a few years. So, but there are also contracts that we have seen that are going as long as 7 years, some going for even 10 years. But then that will also then lead to the issue of compensation. How is the compensation being handled? There are so many other clauses that people have to put in terms of compensation other than the salary. What are the bonus claims? What are the intellectual property rights? Those are now, again, something that is very evident. Now athletes are more aware of their image rights, that is what is being shared, for instance, by the team. We have had cases of even our national football team having a dispute where somebody would the sponsor would use the image of the team on a billboard, and a player is complaining, saying that I'm not being paid any additional amount, and then why is my image being used here? So some of those things have to be clearly stated out, and I would say that when you are doing those contracts, you need to be very careful so that you don't fail your client. It doesn't come out as a drafting failure, that you did not spot that let me say something like, for instance, renewal. If you don't put in a proper renewal clause, what happens? Or does your client then end up having their contract terminated just by the function of time? So it's important that those are properly captured, because now those are the things that those who are hearing the dispute, whether it's a Sports Dispute Tribunal or whether it's arbitrators appointed to hear the matter, will then be looking into, because then it becomes an issue of interpretation of such clauses. And in terms of jurisdiction, again, I will say that one of the things that we are facing as a tribunal is a lot of jurisdictional challenges, because people come and the first thing they say is a preliminary objection in respect of jurisdiction. You do not have jurisdiction. Again, it depends on how then that person approaches the tribunal. If it is an employment dispute, for instance, we have the specialized courts for that, under Article 162 of the Constitution. So you'll find there are people who will then say this is an employment dispute, it should go to the ELRC. But there are those who come to the tribunal saying it's actually a breach of contract. If you bring it as a breach of contract, maybe the tribunal can then have a look at, are we then looking at the employment issue, or are we looking at other contractual issues related to that sports contract? Because I would say sports contracts for employment are usually sui generis. There are things that are there that we'll not find in other contracts of employment. Transfer fees, solidarity payments, the early termination, all those are some, or even performance measures, where people who are not maybe scoring goals, then there's a transfer season. How do you internalize that now in the normal commercial contract or in the normal employment contract? So those who are drafting those need to be very careful, so that the seat of where the dispute should go is very clear.
And maybe even just to pick up from what you've said about jurisdiction. And you earlier talked about the internal dispute resolution mechanism, the tribunal, and then the court for arbitration for sports. And I think is it in Zurich, or where is it in? It's somewhere in Europe. For arbitration for.
It's in Lausanne. Yes.
So the question I have is: would you see a situation where the African continent is beginning to reimagine some of that arrangement, so that then, because I believe in Africa we have the capacity to be able to even formulate our own homegrown, African-grown tribunal or appellate procedure, or maybe even just think about an institution, regional institution, arbitral institution, or alternative dispute resolution mechanisms that would then fit in to be able to address some of those. Is that something that you would see in the future as being a possibility?
I am a proponent of having disputes resolved at the source, where the disputes are arising. And so having to go to Europe, in my view, is not something that is very ideal, and it would be good for us to have actually disputes being resolved, even if it means having, for instance, a seat of arbitration for CAS within Africa, and preferably in Nairobi. But when you also look at the arbitrators that CAS has, we then need to build capacity, because I think if you look at I don't think we have more than one arbitrator listed for Kenya under CAS. So we need to actually grow those numbers. I think South Africa and Egypt have about 6 each. So you see, then they seem to be having more of those arbitrators. So we need to have more people being also listed as CAS arbitrators. But I'm a proponent for having local solutions, because I believe that our situations can be unique in Africa. If I just give you an example, for instance, a football match that happens in Kenya, you'll find that the local teams don't own the stadia, so it's mostly government-owned stadia through Sports Kenya. But in Europe, that's a very different situation, where you find the big teams own the stadia. And I remember one time I was appearing before somebody who was resolving a dispute, and they were asking a question that was very different from our scenario. They were asking, this team, what was their away allocation? And this is Kenya. I'm wondering. I was telling them, people working, you pay them. Yeah, even where you sit sometimes can be just freestyle, sitting. So, that's a unique scenario in Africa. Look at things like transport. In Europe, I think transport is more, it's more developed. In Africa, if somebody is traveling for a Champions League match in Kenya, sometimes they may have to go to actually Europe before they connect now to Nairobi. And so if there's a dispute that arises and a match is not held because there was a lack of connecting flights, you see, that's a very African problem. And I think sometimes when you have those people who are experiencing it, it might be easier for you to have them hear that dispute rather than have it, in another forum. So I'm actually a proponent of us doing this in Africa, but then also building the capacity. We can't have one arbitrator, for instance, in Nairobi, and then say that we need to have Nairobi as a seat of arbitration. And then that, I think, brings it to you now as NCIA, looking at those numbers, looking at the speciality of sports. How can you grow the numbers? How can you then make sure that those other people within the continent in Africa, those other countries, they can actually rise to that occasion and take over that sports space? How does NCIA look at this?
Then thank you for that question. Actually, I'll start with something you said, that we only have one arbitrator in the Court for Arbitration for Sports. And I think that is a great indicator for where, as NCIA, we needed to grow the awareness about sports disputes and how they are handled. And I think this is why I must thank you for actually bringing it up, because then our role is to encourage the growth of numbers. So we have several programs that we do at NCIA that aim at answering the question that you have posed about capacity building. So we have arbitration training programs that are more geared towards training and equipping practitioners with the skills to be able to handle alternative dispute resolution, and in particular in arbitration. So we train them. We will go through the modular process, where we begin by training training the participants on the basics of arbitration, to now going further. And at the third stage, the third module, we now specialize that. So if somebody is interested in arbitration for sports, then now we can curate that program that will then address them to train them on those specific skills that are needed at the international arbitration level. So we are doing a lot of capacity building. I think so far this year we have almost gotten to, I think, about 400 participants who are trained in our programs in different levels, whether it's mediation, arbitration, and basically just creating that awareness. But I think the first starting point is what you said, trying to get more arbitrators to be in the Court for Arbitration for Sports, at least for Kenya, because I believe that Kenya, and in particular Nairobi, has one of the greatest potential, because any Olympics that you would think about, Kenyan athletes are always a prominent feature in that. And therefore, I think our arbitrators, our lawyers, our practitioners in ADR spaces need to take up this as an important space, so that then we can project that. And as NCIA, we are engaging with them, and not just the ones who are already converted, but also even the coming generation. We are trying to engage with university students. We're engaging with young professionals in the young lawyers, young engineers, young practitioners, basically, who are beginning to enter into the market space, to train them and to advise them, and to create that awareness of the existence of alternative dispute resolution mechanism, and in particular arbitration for sports, mediation for sports, and every other kind of dispute resolution platform that then may be applicable for the unique cases that we have. And what I can say is that, given the numbers that we see being admitted into the bar every year, I think as NCIA we have identified a potential for us to grow awareness, so that in the next maybe 10-15 years, the young professionals who enter the legal or the law practice area, they have become aware of that. So we are beginning to engage them at the university stage, and equipping them and preparing them to be aware of the pathways for dispute resolution. And I would like to know how also, as a tribunal, or even just in the sporting industry, how are players engaging with, how are the players in that industry engaging in terms of training, capacity building, or even as a tribunal, what are some of the initiatives you think would be useful or have been useful for purposes of growing capacity, and especially for alternative dispute resolution?
First, let me just mention that I do appreciate the work that NCIA does. When I attended the arbitration week, I actually met a lot of university students who are in that forum, and some of those who actually engaged in who are interested in sports law, who actually we took their contacts, and we've been in communication about it. So it's something that the next generation actually needs to also learn from us, so that we are then able to to take it up. They can take over from us. But in terms of the tribunal, we are also engaging in capacity building, because we realize that even what we talked about, the internal dispute resolution mechanisms, we need to have them work. We need to have people there who can actually make the internal dispute resolution mechanism work, because if it doesn't work, then we have more cases, at the tribunal. We need to have people who appreciate the basics of dispute resolution, the independence, the impartiality, the integrity, so that you do not have federations, for instance, appointing their friends, as the people who should hear disputes. So access to justice has to be a paramount feature to them, and we are engaging them. I've actually attended sessions with the presidents and secretaries general of the federations last year, and then this year during the Judiciary Dialogue Day, we also met the technical staff, especially on issues of selection, so that we actually tell them these are some of the things you need to do. If you need to select a team, you must have a selection criteria, basically trying to take out the things that they usually do wrong, so that then we avoid those conflicts. So we are actually doing a lot of the training. We are also trying to ensure that there is a lot more interaction. We are having media outreaches. We have signed a memorandum of understanding with the sports journalists, so that even journalists can also then put out the word there, because if more athletes see that this case is being reported, or you can actually dispute a selection, for instance, that then gives them that awareness. So the awareness is also going on, and so that then we are able to get as more people coming into this space. And then there is also currently a sports bill that there was a certain committee that worked on it. It has submitted it to the cabinet secretary in charge of sports. It hasn't been presented to Parliament yet, but it should be. It's under circulation. Actually, it's found on the website for the Ministry of Sports. And amongst the things that it has actually indicated is for instance, the persons to be appointed as chairperson of the tribunal should be persons who also have experience in arbitration. So you see that was not there in the current act. It just talks about you must have experience of a high court judge. But now there are actually even specifics that now are being added to that, and arbitration is one of those that is being added. So it means that those who actually aspire to resolve disputes then also need to have this as one of the things. But I'm pleased to note that I'm an associate member of the Chartered Arbitrator, so it's something that I think should be encouraged, so that as many practitioners as possible then also take up this. And even those who now appear before us, who may not be arbitrators, but also then want to just practice, they also need to be, there needs to be capacity building for those. And we have actually engaged various organizations that are also training. We have actually had several trainings with our bar bench. We have a very active bar bench committee at the Sports Dispute Tribunal. They've actually organized trainings with the Court of Arbitration for Sports. We've organized with the World Anti-Doping Agency and also the local bodies. And so we actually also capacity building, so that people then also know, what do I need to do when I come before? How do I then bring the matters before for resolution?
Yeah, thank you. And I think this is a really good way to both train what we have now, the people we have now, train them, but also for future generations, to prepare them for dispute resolution. So I want to thank you very much for taking time. I think we have to come to an end of this engagement, and maybe I'll invite you to give maybe your closing remarks on this, but also just to say that we have a lot of information about some of the services that we offer at NCIA and some of our programs. I may not be able to do that in a very short sitting like this, so I would invite the viewers to look at our rules, look at our processes. All of that information is captured in our website. Look at our act, and I know also you have, I think you have also a website.
Yes, the judiciary website has that.
That has the information on the procedures and all that. And maybe invite you to maybe give your thoughts, closing thoughts, and then we can bring it to an end.
Thank you. Thank you for this conversation. I think the industry of sports is a very important industry. It has moved from just being recreational to actually being an important industry within the country, and it actually transcends even to the other sectors, the construction, as you mentioned, tourism. You saw what happened with Magical Kenya the other day, the Safari Rally. There's a lot that actually sports does, and so people right now are even choosing sports as a career pathway in the CBE. So it is something that is going to be with us for a long time, and those disputes are inevitable. We have to find ways in which we have to resolve them. The Sports Dispute Tribunal is available to resolve those disputes, and our decisions are usually published on Kenya law. So if you go to Kenya law and you just even check the Sports Dispute Tribunal, you can actually see the decisions that are there. We have our various we also have our various mechanisms in which we also reach out to people. So when, for instance, even on social media, we have our Twitter handle, SDT Kenya. People can also then follow, so that they can then be able to get the various happenings that are there at the tribunal. And we stand by our motto, which is justice in sports. So we invite those who wish to pursue justice in sports to also appear before the Sports Dispute Tribunal.
Well, thank you so much, Bernard, and thank you all the viewers. I think we bring this to a close, and invite you to engage with us in our different platforms. Thank you very much.
Thank you.